Yes, my Lord. Just for the benefit of the court, the approach I will now take in light of Mr. Justice Andrews' position in terms of starting on the evidence first, I'll take the court through the respondent's position, the legislation and regulations, and show why the High Court Enforcement Officer cannot be a respondent to an 84.16 application, supporting principles behind agency and vicarious liability, the respondent's notice of the paragraph 60 in relation to paragraph 66 of Schedule 12, and that in any event, vicarious liability or otherwise, why those principles do not pertain to a fees assessment application under Rule 84.16. I'll then tie that back up to show why, on the evidence, the approach taken in this case by the High Court Enforcement Officer was the correct one. I'll produce some sweeping up submissions in response to my learned friend submission that he made earlier, if I haven't already done so within the meat of my main submissions.
Yes, thank you.
So, in a nutshell, it's the respondent's position that the first appeal decision and the first instance decision were correct, that the first appeal judge, Mrs. Justice Lambert, was correct in finding that the respondent was couldn't be a respondent to a fees assessment application. When I say a fees assessment application, it's a summary for the position under Rule 84.16, and that he cannot be a respondent to such an application. And in support of that, that a High Court Enforcement Officer doesn't fall within the definition of a related party under paragraph 66 of Schedule 12. Starting first,
would you accept that if he did fall within the definition and we were against you on that point, that he would be a proper respondent?
No, my lady, I wouldn't accept the position. What I would say is, if he is considered to be a related party for the purposes of paragraph 66, Schedule 12, which is essentially a damages claim, that would be separate to a Rule 84.16 application, which is in respect of a fees assessment. It is in a similar vein to a detailed assessment or a summary assessment of costs. And I will make that submission in due course, because when one looks under the High Court Enforcement Officer's regulations, that also has a specific provision about the assessment of costs charged and recouped by a High Court Enforcement Officer. So it's a very similar provision. What I would say is that provision applies to enforcement officers, whereas the Rule 84.16 procedure applies to the enforcement agent, because it is his fees that are being collected. So, starting first from the top, because Part 84 and Rule 84.16 deals with the procedure for a fees assessment application, the Rule 84.2F of the CPR confirms that an enforcement agent has the meaning given in paragraph 2, subsection 1 of Schedule 12. So that's my starting point. With the court benefit to turn to that particular provision, it can be found bear with me, at tab 6. I believe, yes, tab 6, page 18 of the authorities bundle. So you can see at 84.2F, enforcement agent has the meaning given in paragraph 2, subsection 1 of Schedule 12. Then taking the court through to paragraph 2.1, which is set out further down in tab 9, page 62. It's confirmed there at paragraph 2.1 that an enforcement agent means an individual authorised by section 63, subsection 2, to act as an enforcement agent. I'll come back to what is set further below at paragraph 2, 3, and 4 in relation to the authorisation of someone other than an enforcement agent if he's not the person whom an enforcement power is conferred. But I will say at this juncture that in my submission, which I'll develop in due course, that person wouldn't be the High Court Enforcement Officer. It would in actual fact be another potential other enforcement agent that instructs another one to conduct the works on the ground. And in support of that, if one looks at subsection 4 of paragraph 2.4.
Are you saying that the person on whom an enforcement power is conferred is referring to another enforcement agent?
Yes.
But there must be an end to that, mustn't there? Because ultimately, there must be somebody upon whom the enforcement power is conferred.
I would say that that person, my lord, is the enforcement agent that initially gets instructed by the High Court enforcement officer. That will be the first person in line.
Is it the instruction that confers that power on him then? Where does the power derive from?
The power in my submission, my lady, derives from the writ. The references...
Yes, exactly.
So
the person to whom the writ is directed is the High Court enforcement officer, not the agent. So a person on whom an enforcement power is conferred can only apply, surely, to the High Court enforcement officer.
In my submission, madam, and again, I'll develop this due course, but answering the point directly now, is that the writ directs it's directed towards the High Court enforcement officer. I accept that. The wording of the writ is actually not in line with the definition of an enforcement power under Schedule 12. What the writ says, and actually it might be worth just dealing with this now, given that we're on the point. If I could turn your attention to the definition of a writ, it's in the supplementary bundle, page 9.
An example of it.
You can see on the left-hand side of the page the command to Mr. Williamson, the High Court enforcement officer. It says, to seize and execution the goods, chattels and other property of the defendant authorised by law and raise therefrom the sums detailed in the schedule, and immediately after execution to pay the claimant the said sums and interest. That's the command.
You've missed out the fees and charges to which he's entitled.
Yes, and the fees and charges to which he is entitled. That's the command, and that's the wording within the writ. Now, in my submission, this point I will come on to in due course. The fees and charges reference could only be the fees and charges to which he is entitled, which are the ones that could only be under the High Court enforcement officer's regulations, or it might be for some other reason. If the enforcement agent collects the charges to which he is entitled, there may be, and I appreciate the court's stance when discussing the matter with my learned friend earlier, there might be some form of a contractual arrangement. There's no evidence in this case, unfortunately, of the position. There might be, but it's a bottom-up position. So it's the enforcement agent's fees, and then that gets divvied up and paid across in whatever agreement there may be to the High Court enforcement officer. Not that the charges belong to the High Court enforcement officer, get paid to the
You are going to show us
agent.
in due course the provision that says that an enforcement agent is entitled to charge fees.
Yes, I will do, my lady. I will discuss the position that the fees regulations relate only to the enforcement agent's charges and fees that belong to him, and the reason why I say that.
But there's nothing in this writ which entitles the enforcement officer to seize goods for sums other than, in relation to fees, other than his fees. Doesn't entitle him to seize goods in relation to somebody else's fees.
Well, I appreciate it. I appreciate it, my lord. I believe the way in which these writs have been produced do not necessarily tie in that well in terms of its wording with the way.
Well, on your case, they don't tie in very well.
That's right. I appreciate it's my case.
But on the appellant's case, it's perfectly correct.
Well, the reason I say it doesn't tie in that well with the current modern legislation under Schedule 12 is because the definition of an enforcement power is contained, and it's at page 61 of the authorities bundle. So there's two provisions there. So paragraph 1.1, using the procedure in this schedule to recover a sum means taking control of goods and selling them to recover that sum in accordance with this schedule and regulations under it. In this schedule, a power to use the procedure to recover a particular sum is called an enforcement power. So in a nutshell, an enforcement power is really the ability to use the procedure to take control of goods and sell them under Schedule 12 alone.
So the writ is meaningless.
So the writ, I would say, isn't necessarily meaningless, my lady. What I would say is that when a writ gets directed to a High Court enforcement officer, the writ in and of itself contains the enforcement power that gets, because the definition of conferring that power comes from the writ. And I'll turn on to the various provisions within Schedule 12 and otherwise that refers to the writ conferring the power.
Well,
The writ
I'm not following the argument at the moment. It's my fault, I'm sure. You accept that the enforcement power derives from the writ?
Yes. Yes.
Right. So the provision on page 61, subsection 2, that you have referred us to,
Yes.
is that a reference to the same power that derives from the writ or a different power?
It's the same power that
Right. So the source of the power is not Schedule 12, it is the writ.
The source of the power is the writ, yes.
And the writ is addressed to the High Court enforcement officer and not to an agent.
It's directed to the High Court enforcement officer.
So you've got a power to use a procedure, which is a power that's derived from the writ, and that is what is the subject matter of the schedule.
But when you say schedule...
In this schedule, a power to use the procedure is called an enforcement power. Yes?
In this schedule, yes, it's Schedule 12.
Under Schedule 12, there is a tying in with the power that is devolved upon the High Court enforcement order under the writ.
Upon the High Court enforcement officer, my ladies, that would...
Yeah.
Note, in my submission, it's not devolved upon the High Court enforcement officer at all, because the only person who can exercise an enforcement power is the enforcement agent.
Well, that's the problem I have with this submission, because if you accept that the enforcement power is derived from the writ, which is addressed to the High Court enforcement officer, and the schedule refers to that power, then it can only be exercised either by the person to whom the writ is directed or by somebody who he authorises.
Well, when one looks at the wording of what the enforcement power is, it does not tally up with the wording of what the writ is, what the writ mentions. The writ does not mention the ability of the High Court enforcement officer to take control of goods and sell it under Schedule 12, under the Schedule 12 procedure, whereas what paragraph 1.1 onwards of Schedule 12 refers to as an enforcement power is the ability to take control of goods and sell them in accordance with this schedule.
So the words "seize in execution" and raise therefrom the sums detailed in the schedule together with fees and charges means something different from take control of the goods and sell them.
Well,
is that the submission?
Well, it's part of the submission, my lady, that it's not... the enforcement power is conferred by the writ, but it does not go to the High Court enforcement officer. It goes to the agent that is instructed by him. The High Court enforcement officer does not hold the enforcement power, or it's not conferred upon the enforcement officer. It's conferred upon the agent alone. He's the only one able to exercise it and use it.
But where he's authorised by the person on whom the power is conferred.
In my submission, it would simply be an instruction, not an authorisation. There's no power held by the High Court enforcement officer. It's the writ confers the power directly upon the agent.
Well, I don't begin to follow that.
I don't understand. How do you define that? We know that the writ confers a power on the officer, because it says so, and we know that the agent must have authorisation from the person upon whom the power is conferred.
It's my submission that the writ does not confer the power of the High Court enforcement at all. It's only conferred upon the person who's instructed by him, that's the agent. And that's part of the submission which I'll come on to, is because the enforcement agent is the only one who's able to take control of goods and sell it under the enforcement power. Otherwise,
Yes, that's only if he's been authorised by the person upon whom the power has been conferred.
in my submission, and again, I was going to raise a bit later, is if a power is conferred upon someone who can't use it, it just doesn't make logical sense with the definition of what an enforcement power is, which is the ability to use Schedule 12 to take control of goods and sell it. So
well,
here,
no, you could confer a power upon somebody which is in practice exercised by him or by somebody else upon whom he's devolved authority. All of that makes complete sense, and it's consistent.
I appreciate your position. My lady, at
the moment, I'm just trying to understand your submission. I'm not making life difficult for you for the sake of it. Please, bear with me. But I'm just trying to get my head around this submission that the writ doesn't confer any power whatsoever on the High Court Enforcement Officer.
What might help, my lady, is if I carry on with my submissions, because in due course that position hopefully will elucidate in itself in terms of what I am saying. So,
what is the point in calling somebody an enforcement officer if
they can't enforce?
If they have no power, it just all seems to me. What is the point of a High Court enforcement officer? Why do we have them?
My lord, if one looks at paragraph 2.2, apologies. This. Bear with me, my lord, as I get the correct provision up. Paragraph 2.2, yes. It says only an enforcement agent may take control of goods and sell them under an enforcement power.
Yes.
So the only one who actually holds that enforcement power, in my submission, is the enforcement agent and not the officer. He's the only one able to actually use it. And
no, that's not what it says. It says only an enforcement agent may take goods and sell them under an enforcement power, and then that is explained in 3. If he will either be the person upon whom the power is conferred, or he's authorised by that person. So, from my own position, I have to say, it all seems quite clear to me, which is that the power is conferred on the HCEO under the writ, and either he himself is an enforcement agent, in which case he can enforce, or he has to authorise somebody who is an enforcement agent. That seems to be as clear as crystal to me.
Well, if I may carry on with submissions, hopefully
yes.
We'll come back that position is it appears clear in the face of it. In my submission, isn't that clear in terms of the position you are raising? Right. But carrying on further, there is within the authorities bundle yes, page 633 of the authorities bundle. This is the Civil Procedural Rules Committee's position in terms of the commentary in the White Book, which accords with my understanding as submitted to you, or at least partly accords with my understanding.
Right.
So the third sentence down at 83.0.7.
Well, just a chance to get there, please.
This is... So this is part 80. These are the notes to part 83.
Yes, which relates, my lord, to the taking control of goods procedure under the 2013 regulations. But it's as one can see there, schedule is referred in the third sentence or third line down. Schedule 12, paragraph 2.2 permits only an enforcement agent, and brackets, or someone authorised by such an agent, as defined by section 63 of the Tribunals Courts and Enforcement Act, to exercise this enforcement power.
That begs the question of who's an enforcement agent, which turns the argument circular.
Well, my submission, the reference to an enforcement agent is the one as defined in Schedule 12. And it can only be because that's the only reference made. It doesn't make reference, my lady, with all due respect to a High Court enforcement officer at all.
Well, the Rules Committee does side with you in relation to the need for a certification if the HCEO is going to do the enforcement himself. That's in the commentary under 8305.
That's correct, my lady, and I'll come on to that, which lends support to my argument that a HCO is not exempt for the under the provisions as to who can be an enforcement agent. In terms of my submissions,
But of course, this is just a commentary.
I appreciate that, my lady, but of course, the White Book is widely used. The commentary is widely used,
And sometimes it gets it wrong.
Well, no doubt the commentary will be rewritten to reflect whatever judgment we give.
Appreciate that, my lord. I can't get away from that, but as it stands, it's
No, it's helpful. No, you're absolutely right to share us. Yes.
But are the regulations using the phrase "an enforcement power" in two senses? Because if you look at paragraph 2 of Schedule 12, sorry, not the regulations, Schedule 12. If you look at paragraph 2 of Schedule 12, subparagraph 2 says only an enforcement agent may take control of goods under an enforcement power. But then subparagraph 3 assumes that there's a different sense to be given to enforcement power, because he's an enforcement agent if he's not the person on whom an enforcement power is conferred. So it seems to me, possibly, that what's envisaged is enforcement power as defined, plus a different enforcement power, i.e. the enforcement power conferred by the writ. Which is why the phrase is an enforcement power, not the enforcement power. I don't know whether that makes any sense to you.
Marty, it's definitely a worthwhile observation. I'm just having a moment to think about its consequence. Well, going back to paragraph 1.2, which is just the page above, my lady, there's a reference that says, in this schedule of power to use the procedure to recover a particular sum, it's called an enforcement power.
Yes, that's my point.
Now, there is the argument, and I believe a strong one, which is that there could be more than one enforcement power in the sense that you could have more than one writ.
Yeah, but let's look at the position where there's just one writ.
Yes.
It seems to me that that writ is the enforcement power, or confers the enforcement power. Whether you call it the enforcement power or an enforcement power, that is what we're talking about. And as I understand it, there is somebody on whom that power is conferred. But then there is the question of who can actually take goods under that power, and it's either the person on whom it's conferred, or it is somebody who has who's been authorised by the person on whom it's conferred. There's only one power.
I appreciate it, my lord. What I would say is, for the principle, if there is an authorisation, setting aside my main submission, which the writ doesn't confer the power upon the officer himself, the officer directed to enforce the writ, but the writ itself confers the power to use the Schedule 12 procedure, which can only be conferred upon someone who can use it, in my submission. Yes. Putting that to a side, there's the point that if there is an authorisation, there would be some form of a principal-agency relationship between the High Court enforcement officer and the enforcement agent.
Yes.
Taking that a step further forward, this is addressed within my skeleton, paragraph 22 onwards, which is that...
Can you just give me a moment?
Yes.
I was just in the supplemental. So your skeleton at page...
It's paragraph 22.
What page of the bundle is it? Tab 12, is it?
page 107 onwards.
Yes. So paragraph 22. Yeah.
118.
It's paragraph 22 onwards. I'll give the court a moment to read what I've said there.
Well, it presupposes you're right that the HCEO has no power.
Apologies, madam, I didn't follow.
The argument that you make there is premised upon the suggestion that the HCEO has no power. If he has no power, he can't devolve the power on his agent. He does have the power, he can.
Yes, it does. I appreciate that.
But that's your argument, isn't it?
Well,
'Cause as I understand your argument, you're saying X as principal can only grant Y as agent the same power that X has. Right?
Well,
So if X has no power, he can't devolve that power on Y. Absolutely right.
if I can ask the court to turn to paragraph 25, which is just the page over in my skeleton. So this principle makes very clear that the person, so say principal, has capacity to authorise an agent where the act can be done by the agent and the principal would have capacity to do the act himself. This comes from Treaty on Contracts. Within the authority bond, I'm sure, my lady, you will...
Well, it's trite law, but it all presupposes that the High Court enforcement officer has no power. If the High Court enforcement officer does have the power, then he can devolve it upon an agent. If he doesn't, he can't.
In my submission, the power would only arise, or that relationship would only arise if the enforcement officer could do the act himself. That principal-agent relationship could only operate in that way. So in this situation, the definition of enforcement power, as referred to earlier, is the power to use the procedure under Schedule 12. What we do know is that only person who has the power to use the procedure is an enforcement agent.
That comes back to the issue of whether a High Court enforcement agent is also an officer is also an enforcement agent.
Well, yes, I'll come on to that, my lord. In due course, it all ties in my submission at least, and I appreciate the court has a particular view at this juncture. It ties in quite neatly with that position, which I will say is that the High Court enforcement officer doesn't fall within the category of an enforcement agent unless he is certificated. But therefore, based on this submission on agency, yes, there's an element of presupposing that the enforcement officer doesn't have the power, but in actual fact, to have that power, you'd have to have the ability to do it himself. Otherwise, how can you authorise someone to do it?
Suppose he is certificated. Let's just take your argument at face value and assume he needs to get a certificate. So a High Court enforcement officer gets a certificate that enables him to act as an enforcement agent. And your argument is also that subparagraph 3 of Schedule 12 enables one enforcement agent to authorise another enforcement agent to go in and seize goods. In those circumstances, is the High Court enforcement officer who's got the certification the principal of the other agent? And in those circumstances, can he be vicariously liable for the acts of the other agent?
Madam, that's a question I've not thought of to that extent. So the question is whether or not an enforcement officer is certificated, but he's acting as a High Court enforcement officer, whether therefore an agent's actions would hold him vicariously liable for those wrongful actions.
He's certificated as an agent, but he chooses not to do the execution himself, or he devolves some part of it on another enforcement agent. But he then, because he's got the certification, on your argument, he now has the power under Schedule 12 to do it himself, because he's got the certificate, right? So now he's got that power, and he devolves that power on somebody else, or shares it with somebody else. Is there a principal-agent relationship between them such that he would be vicariously liable for the acts of the other agent?
In my submission, no, because the High Court enforcement officer wouldn't... he'll be operating under the confines as a High Court enforcement officer, not as an enforcement agent. So in that situation, he wouldn't be. But I'll come on to vicarious liability in due course anyway, irrespective of that position. He would be held vicariously liable.
We're going to have to let you make some progress, I think. But no, not all. But can I? Just one thing I just want to understand about this case from what you said. Mr. Brown was the enforcement agent. Where did he get his authority from?
To enforce under Schedule 12.
Yes.
Outside of the legal sense, he was instructed by the. I can't take away the fact that he was instructed by the High Court enforcement officer. It wasn't authorised.
But you say he can't authorise.
Well, what I would say is, he's authorised in the sense of being instructed, but that doesn't confer that's not where the High Court enforcement officer doesn't hold the power to confer the enforcement power that the enforcement agent holds from that authorisation.
So again, where does Mr. Brown get the power from?
From the writ. He gets the power from the writ being directed to the High Court enforcement officer, who duly endorses it. And when he gets instructed, the power is from the issued writ. If there's no issued writ, there is no power. In my submission, the power comes from the writ.
So you're saying that, but the writ, who is it who does? How does the writ confer power on an enforcement agent who isn't named in it?
In my submission, it doesn't have to be. We've got Schedule 12 to tell us how it's conferred.
Yeah, and show me. I'm just not understanding this. So there's a writ issued, which is the enforcement power. How does it confer that power on Mr. Brown? Looking at paragraph 2.
Bear with me, my lord, as I put the right provisions.
It's page 62 of the authorities bundle.
Yes.
So looking at it now, an enforcement agent, that is Mr. Brown, if he is not the person on whom an enforcement power is conferred, well, he's not named in the writ, it's not conferred in him, may act under the power only if authorised by that person. So, please, can you explain? Because I have to say, I'm finding this really difficult. How does Mr. Brown become an enforcement agent here?
So when the writ gets issued, it's endorsed by Mr. Williamson. At the point of its issue in my submission, the writ contains the enforcement power. It gets conferred when he's instructed by Mr. Williamson. That does not mean Mr. Williamson holds the power. It gets conferred from the writ from the moment of his instruction.
So Mr. Williamson doesn't have the power.
No.
And he isn't authorising, but somehow he has some undefined power he confers it on his choice of enforcement agent.
Confers, my lord, the enforcement power?
Yes.
He confers a power he doesn't possess on somebody else.
But subparagraph 3 seems to assume two things. It seems to assume that an enforcement agent may be not the person on whom an enforcement power is conferred. So, in other words, the person on whom the power is conferred is somebody other than the enforcement agent. And in that situation, the assumption is that the person on whom the enforcement power is conferred can authorise the enforcement agent. And that seems to run contrary to your submission, doesn't it?
Well, the person who can authorise it in that situation would be another enforcement agent who holds the power. That's
circular, because that agent will only have got the power from the person who's conferred it on them.
So if I take a step back, the way I see it, as per my submissions and the reading of the legislation, you have the High Court writ. The writ is endorsed by the High Court enforcement officer. The High Court officer, whether the word authorised is used, I would use the word authorised, but not in the context of there being a conferral of the enforcement power. So he authorised in the sense of he instructs an enforcement agent to enforce that writ. At the point of its instruction, at the point of the authorisation, the writ in and of itself confers the power upon the enforcement agent. The enforcement agent can say, look, here's the writ, and I can now go and do this job.
Show us where that arises on the writ.
Yes. So we have, first and foremost, if I am right about the particular the provisional reference here.
Page 9, supplementary bundle, I think.
Apologies, my lady, was there a particular page number that you were looking at?
Page 9.
Page 9.
We're looking at the writ, it's on
bundle.
page 9.
You said it was endorsed by Mr. Williamson.
Yes. In terms of the wording of writ conferring power, it's mentioned in numerous times within Schedule 12, but also within the fees regulations. So, for example, Regulation 4.5 and Regulation 6 of the fees regulation, which, bear with me. Yes, page 114 of the bundle, of the authorities bundle. We see that's paragraph 4.5 or regulation 4.5, where the enforcement agents act under an enforcement power conferred by a High Court writ. Mm-hmm. It doesn't say conferred by the High Court enforcement officer under the writ. It says conferred by a High Court writ.
No, but that's shorthand for the regulation, what's set out in Schedule 2, paragraph 2, isn't it? So just repeating that.
It doesn't repeat that, my lord, at all. The wording is High Court writ. It's mentioned there. It's also mentioned within the explanatory note to the fees regulations as well, which can be found bottom of the authorities bundle at page 638 onwards. Where it says, pause for a second. First paragraph, the last two lines. The Schedule 12 procedures available where an enactment, writ or warrant confers the power to use the procedure. So again, it's talking about the enactment, writ or warrant conferring the power to use the procedure. Again, it doesn't say the High Court enforcement officer conferring the power to use the procedure. It says the writ.
Well, the writ's the original source of the power, but the HCEO can authorise an enforcement agent to act under it.
I don't take issue, my lady, with the fact that there's an authority in the sense of the High Court enforcement officer saying, you, Mr. Enforcement Agent, you can go now use your Schedule 12 powers to do the job.
Well, that's the only way it can happen.
Well, yes, but in terms of the conferral of the power or who the power is vested in my submission, it cannot be in the High Court enforcement officer because it's the writ that confers the power directly upon the enforcement agent.
Okay, so I think we've understood your submission.
Yes.
That the High Court enforcement officer doesn't have any power himself, and that in some way, by instructing the enforcement agent is thereby authorised or gets the power from the writ. That's your submission. And
yes,
and we will make of that what we will. I don't know whether or not is your it seems to me the key argument here is who has to be a respondent in relation to
that's right.
fees dispute. Is your argument on that dependent upon being correct on this first submission?
Not necessarily.
No, I wouldn't have thought it is. I wouldn't have thought it would be.
But in the event that, if you find against that point, yes, it's not the only way in which I would argue that the High Court enforcement officer cannot be a respondent to an
Yes.
4.16 application. It is a key point in showing why he cannot be, and also for the purpose of the related party under the respondent's notice, which again I'll come on to in due course.
Yes. Well, I think this first point, which I think you'll see that we've been debating for a while. I think we do have to move on from it, because I think we could spend if we keep on
Yes.
challenging you on it. I think when we're going to run out of time for your perhaps more central points.
Yes, my lord. I'll move on. I'll just double check from where I shall. Yes. So we turn then to still looking at the legislation, still looking at the learned friend described as a labyrinth to get through.
Yes.
We have paragraph 62(1) of Schedule 12, which the court will find with the authority bundle again.
Yes.
Tag
62.
9. Page 72, which confirms that regulations may make provision for the recovery by any person from the debtor of amounts in respect of costs of enforcement-related services. Enforcement-related services is defined at subparagraph 5 as anything done under or in connection with an enforcement power or in connection with obtaining an enforcement power, or any services used for the purposes of a provision of this schedule or regulations under it. For my submission already made, anything done under or in connection with an enforcement power, in my submission, which I'll make a due score, is the work done by an enforcement agent on the ground, which incurs the relevant fees in those relevant stages. Anything done in connection with obtaining enforcement power, and this goes back to my submission, I'll only make one line of it, is that could only be in relation to any work done in terms of an enforcement agent instructing another one to do the job, any costs incurred in that respect. On my case, at least, that would be the only way in which that would work. Or any services used for the purposes of a provision of this schedule. That could be, for example, an auctioneer's costs, or any costs involved in actually providing the service of taking goods and selling them. Regulation 2, I won't ask the court to go through every provision with the authorities bundle. It's set out within the skeleton, effectively verbatim. Regulation 2 of the fees regulations defines an enforcement-related service by reference to that subparagraph 5. So it goes back to that definition. And in my submission, the consequence of that is, since the enforcement agent is the only entity that can exercise, on my case, Schedule 12 enforcement powers, it is that enforcement agent that is the entity that can recover its costs of enforcement in exercising their own defined enforcement powers. If that doesn't persuade the court, then the alternative submission is an enforcement power is defined as one being exercisable by only the enforcement agent under Schedule 12. We have a regulation making provision which says costs in relation to any enforcement-related services as defined by anything done in connection with that enforcement power or in obtaining it or any service in relation to it could only be those belonging to the enforcement agent himself, not to the High Court enforcement officer.
So not the auctioneer's fees either?
Apologies, my lady.
Well, you said the only fees they can recover are their own. So that wouldn't cover the wide scope definition of all the other fees, including the auctioneer's fees.
I may have mispronounced that submission in the sense that when I talk about services, it's the services in connection with maybe instructing an auctioneer, or it's the enforcement agent's costs alone, not the auctioneer's costs of actually selling the goods, but it's the costs involved in an enforcement agent outside of the. Well,
the auctioneer will charge the enforcement agent for selling the goods, or he'll charge somebody for selling the goods, won't he? So who recovers those then? If you're right and the enforcement agent is confined to his own charges, what happens if there's an overpayment in respect of the auctioneer's fees?
So in a situation where the auctioneer is overpaid by the enforcement agent, and then an enforcement agent then recoups those costs from the debtor, or levies those costs, if it's an overpayment, then clearly wrongfully, then in that situation, the enforcement agent is the one under a fees assessment application to be the correct respondent in terms of any challenge to it. It wouldn't be the auctioneer, in my submission.
Well, that depends on the regulations, doesn't it?
Yes, my lord.
Because it says that regulations make provision for recovery by any person. So you have to see what the regulations say.
Well, yes, and coming on to the regulations. So we come on to regulations 2 through to 4. For completeness, we have at page 111, we have the definition of an enforcement agent meaning an individual entitled to act as an enforcement agent by virtue of section 63.2. It makes reference there to not including an individual who may act by virtue of section 63.2c.
But someone who acts in the presence of somebody who is.
Presence and direction of somebody, I believe,
Yes.
For example, a constable or one of the other individuals.
So we can ignore that for the purpose
Yes.
of this argument.
Yes. Then we have regulation 3, page 113. Confirms that these regulations apply when an enforcement agent uses the Schedule 12 procedure. Now, I accept the court's position that it doesn't appear to be anything expressly saying that these charges on the face of the legislation alone belong to an enforcement agent, i.e. it's his fees. This inference I would ask the court to draw from the way in which the regulations operate.
So just to make it plain, Mr. Schrader, we don't have a position. We may have indicated in arguments certain counter-arguments to what you're saying by way of testing them, but we certainly don't have a position until we come to write our judgments. Just want to make that plain. So.
And rightfully so, my lord. I apologise. What I mean by that is
apologise.
Your thoughts.
I'm just conscious that particularly as there may well be others watching that when you keep saying we have a position, we don't.
I apologise, my lord. What I mean is the thoughts of the court.
Yes.
So we have regulation 3 confirming that the regulations only apply when one uses or an enforcement agent uses the Schedule 12 procedure. Then we have regulation 4 following the page down, which in a nutshell sets out the ability of an enforcement agent to recover fees, which includes, and I've already mentioned, where an enforcement agent is acting under an enforcement power conferred by a High Court writ. Now, the key provision within the regulations in my submission which supports the point that these charges belong on the face of the regulations alone to the enforcement agent is regulation 6, which is the following page of 116. Now, my lord, you mentioned in an intervention with my learned friend that the compliance fee belongs to the High Court enforcement officer because of the work, because at that point there isn't an instructed High Court enforcement agent at that point. But the breakdown of the stages are there in terms of the fees that are to be recovered. So we have the different stages. The first at 6.1a, the compliance stage, which comprises all activities, and the key word there is activities, related to enforcement from the receipt by the enforcement agent of instructions to use that procedure in relation to a sum to be recovered, up to but not including the commencement of the first enforcement stage, and so forth. And then we have the second enforcement stage at 6C, again, where the enforcement agent and the debtor do not enter into a controlled goods agreement. All activities related to enforcement from the first attendance at the premises in relation to instructions up to but not including the commencement of the sale or disposal stage. And then we come to 6C2, where an enforcement agent and the debtor enter into such an agreement, but the debtor breaches that agreement, then it relates to all activities related to enforcement for the time at which the debtor breaches the agreement, up to be including the sale or disposal stage. And then finally, the sale or disposal stage, all activities under 6.1d related to enforcement from the first attendance at the property for the purpose of transporting goods to the place of sale or from commencing preparation for sale, the sales to be held on the premises. So we have all this work being done by an enforcement agent. And these are within the regulations, again, we'll come on to the schedule to the regulation, which has a breakdown of those stages. It relates to all work done by that enforcement agent alone, not to work done by a High Court enforcement officer. In my submission, the fees, irrespective of what my submission is on the question of the conferral of power, the fees under Schedule 12, where one is exercising as an enforcement agent their enforcement power that they can only exercise, the fees belong to them, not to the High Court enforcement officer.
So what fees does the High Court enforcement officer not get any fees then?
There's a twofold submission there. The first is, and I didn't briefly mention it earlier, is there may be some form of a contractual relationship between the enforcement agent and the High Court enforcement officer. I can't say that there definitely is because I haven't seen for myself any evidence to that effect. But there may be, but the question becomes is whether or not it's the High Court enforcement officer paying a portion of his fees to the enforcement agent pursuant to that arrangement, whether the enforcement agent is paying a portion of his fees to the High Court enforcement officer.
I see the force of the point that you make about it being the agent who does all the work, and that the statutory scheme says, well, when you're going down Schedule 12 process, basically it kicks in from the moment that the enforcement agent is engaged. But I'm a bit puzzled by the fact that a writ of control in its standard form speaks of the fees and charges to which you are entitled, and that is the High Court enforcement officer to whom the writ is addressed. If that is the case, it's a meaningless provision on the face of the writ because he's not entitled to any fees and charges. The only person who's entitled to them is the enforcement agent.
I appreciate that, my lady. There is some form of a inconsistency between the writ and what the legislation actually says.
What it actually should say is together with any fees or charges to which the person that you authorise to execute under Schedule 12 is entitled.
Absolutely, Mike.
Well, no, because you say there isn't an authorisation.
Oh, sorry.
Yes,
you
primary
say
submission
you
there isn't.
instruct.
Well, there is an authorised. What I will say, there is an authorisation in terms of the fact that there is an instruction by the enforcement officer to an enforcement agent to actually go on the ground and do what they need to do under Schedule 12. But that authorisation doesn't confer the power. That's the submission. That authorisation doesn't confer the power from the writ to the enforcement agent. The writ does that in and of itself based on the fact that the enforcement agent, the fact that there's a writ that's been issued, the fact that the enforcement agent then does the work.
Well, we're back to your first point, aren't we?
Yeah.
Which we've sort of agreed, and I'm sorry if I reignited it, but we've sort of agreed that we understand it and we'll move on from it. Yes.
So may I ask a stupid question, please? Where does the language of the writ come from? Is it laid down in legislation, a schedule to legislation, or do we just not know what the source of the language of the writ is?
I believe there is a standard form of writ. It's mentioned within my learned friend's skeleton argument. You may have this as a standard form of writ of control. If you just bear with me, I can locate that.
Is it one of the standard form annexed to...
Is it a standard form? Yeah. Is it part of the CPR?
Yes.
It is.
Right.
Yes,
Okay.
my lady, yes. And to Lady Justice Andrew's point there, the writ does need changing because it doesn't accord in my submission with what the legislation says. The wording appears to be in some form is esoteric, it's old, and doesn't accord with what Schedule 12 of the Tribunals, Courts and Enforcement Act and the regulations under it say.
There used to be a volume of court forms, didn't there?
There is,
I'm not sure it still is there?
I think we saw something under CPR 84 that refers to the particular form.
Yes. That may be right.
I'll see if I can find it.
Could the parties look up the standard form and send it to our clerks after the hearing?
Certainly, Mother.
Yes, I think this is in standard form, and there are reference in the practice directions to CPR PD 83, paragraph 3.1, mandates the forms. And there are various different forms for Form 53 as a writ of control, Form 54 as a writ of a cost order, and so on.
I'm afraid you were speaking a little bit softly.
I apologise.
Part 83.
Part 83, paragraph 3.1 mandates the use of standard forms. Sorry. Interrupt. They just give form numbers, and then there's a separate. It is in the white book in the second volume, I believe.
Form 53
Probably
to 57.
part of the white book on the website rather than a printed form. The writ of control must be in forms 53 to 57. 53 is the one before you. 54 is one for costs, and there are variations thereon.
Yes. So we have to read these as sanctioned by the rules, the rules committee. So one can't just simply blithely say that the wording is wrong and can be ignored. Do you accept that?
It can be wrong, yes, and it appears to be wrong with the base of the legislation.
So there may be, well, if your argument's right, there's an inconsistency between something which is sanctioned by the Rules Committee under the powers that are delegated to them and the structure of the Schedule 12 procedure and the fees regulations.
Arguably, and the point really actually is the High Court enforcement officer's regulations also allow an enforcement officer to enforce a writ of control under a different regime. I'll talk about the High Court enforcement officer's regulations in a moment, but it would appear on the face of this particular writ and the standard form of writ that it would relate to a position that existed prior to the Tribunals, Courts and Enforcement Act, where the High Court enforcement officer's regulations applied. Because under that system, there is a High Court enforcement officer in his own name, on his own account, can also enforce a writ by taking control of goods and selling them, subject to Schedule 12, which can only be exercised by an enforcement agent. I'll come on to that in a moment. Just turning back to the system currently at play in terms of the fees regulations, page 119 then sets out the three different stages. And I appreciate that I'm drawing the court's attention to different parts of the authorities bundle, so asking the court to jump around a little. But in support of the schedule, we have the explanatory note, which gives some context to this. So the explanatory notes to the fees regulation at tab 35. And in particular, this is at page 639. We see, just for a second. In respect of the middle paragraphs in relation to Regulation 13, the final sentence is quite telling, because it says there that any fees and expenses owed to the auctioneer and the compliance stage fee for the enforcement agent are prioritised, with the remaining proceeds being divided pro rata between payment of the debt and payment of the remaining fees and disbursements due to the enforcement agent. And we see in relation to Regulation 14 in the middle of that paragraph, Regulation 1516 make provision for disputes about a co-owner's share of proceeds and about the amount of fees and disbursements recoverable by the enforcement agent. And importantly, the first paragraph, 11 and 12, make specific provisions to protect debtors. Regulation 11 requires enforcement agents to minimise the fees and disbursements charged. So my submission, these are fees and disbursements that belong to the enforcement agent alone. Of course, And now, what I am coming on to now is the
Give me what,
specific.
a page, sorry, tab 35. What actually are we looking at?
It is the explanatory note, page 639. It's the explanatory note to the 2014 regulations.
And what do we have at tab 36?
That's the explanatory memorandum.
So, looking at the explanatory memorandum, paragraph 7.3 that we were taken to, what do you say about that?
In my submission, it doesn't accord with the reality of what the regulations actually say and allow for. The idea that one's higher simply because there's a high court enforcement officer involved doesn't accord with what legislation says. But in any event, it could be higher simply for that very reason, that there could be some form of arrangement between the parties as to what portion of that is to go to the enforcement officer. That doesn't mean that those fees don't belong to the enforcement agent. And based on my prior submissions and the reading of the regulations, it points in the direction that the fees and disbursements belong under the regulations and under the enforcement power conducted by the enforcement agent under Schedule 12. Those fees and disbursements belong to the enforcement agent alone.
But what 7.3 says is that the High Court enforcement has a higher cost base due to the personal responsibility of a High Court enforcement officer.
And the fact that they, i.e. High Court enforcement officers, enforce higher value debts.
So it would be very strange to be saying that if, for the fees to reflect the personal responsibility of a High Court enforcement officer, if the High Court enforcement officer wasn't entitled to any of the fees.
All I can say is that that doesn't accord with what the legislation and the regulations actually say and allow for, which is what Mr. Williamson...
Parliament has been told was the intention behind this. It's been prepared by the MOJ and it's been laid before Parliament. So when these regulations were going through the parliamentary process, it was explained on the basis that High Court enforcement officers, there's a greater charging structure because of the matters referred to in 7.3, and that is presumably one of the reasons why it was passed. So we have to look at any other explanatory notes on the basis of that memo, surely.
I appreciate that, my lady. What I would say is the enforcement... Apologies.
No, sorry, my fault. I was talking across you. I just wanted to ask, what's the relationship between the explanatory note that's at tab 35 and the explanatory memorandum? Because I know there are often explanatory notes for legislation, but what's the status of an explanatory note for regulations in circumstances where there is also an explanatory memorandum which is laid before Parliament?
I believe both are aids to... One's an aid to construction, the other is an aid to the context.
But is the explanatory note laid before Parliament?
No.
When you're dealing with regulations?
I don't believe it is,
Right.
my lady. I appreciate the court's view on that particular document, and I can't get away from what it says. But in my submission, it doesn't accord with what the legislation regulations actually say on its interpretation.
Well, if there's a conflict between the language of the regulations and the explanatory memorandum, then the regulations take precedence.
Absolutely, my lady.
Yeah. Okay.
And there is a conflict.
All right.
Whether the position on the ground is something different, which is what the memorandum seems to appear to suggest, is different from what the law actually says.
Okay.
I would ask the court to keep that in mind and to follow what the law actually says, which is, of course, the function of the court in any event. And following further on and I'm coming to a close on this particular point, and moving on to the question of whether or not a high court enforcement officer is exempt, is based on those provisions within the fees regulation, the rule, we have regulation 16 of the fees regulation, which again, the court can find at tab 11. Page 117. Which is that it's upon application in accordance with the rules of court, so we'll come on to 84.16. Any dispute regarding the amount recoverable is to be determined by the court. And the particular rule of court is Rule 84.16 of the CPR, which I believe as well is included within the bundle at tab 6. At page 20. The key point there to note is that this rule applies where there's a dispute about the amount of fees or disbursements other than exceptional disbursements. Exceptional disbursements fall within the definitions in the fees regulations. It's not entirely relevant for the purpose of this appeal. Recoverable under the fees regulations. This appeal doesn't relate to exceptional disbursements. No exceptional disbursements argument was raised at first instance. And then it says, and a party wishes the court to assess the amounts recoverable under Regulation 16. It says a party may make an application to the court. And so a party in my submission would be either the enforcement agent or one of the parties to the proceedings. For the reasons already given, it's an enforcement agent's charges under Rule 84.16. And of course, the parties to proceedings would be the judgment debtor or the judgment creditor, for instance. Then follows on and says that the application must be accompanied by evidence of the amount of fees or disbursements, and there's some other evidence that the court requires depending on the type of dispute to be raised. And we can see at 3C that the evidence that because the enforcement agent was instructed to use the procedure, so the references within the rules specifically point to an enforcement agent, not to an enforcement officer. And
Well, that's in relation to somebody using two different enforcement powers and prioritisation, isn't it?
Yes, my lady. It's just the reference there to enforcement agent.
But we know from the rules that it has to be the enforcement agent who is carrying out enforcement. So that just simply confirms what we know.
That's right, my lord. I can move swiftly on from that.
Forgive me. The question that I think you're addressing is: are the fees those of the enforcement agent or the High Court enforcement officer? And forgive me, but looking at everything through your end of the telescope doesn't necessarily mean that you're looking through the right end of the telescope. We need to find which is the right end of the telescope.
Yes, my lord.
And I'm not sure anything in here actually helps with that question, does it?
Well, not in terms of 84.16, but in terms of the fees regulations as I've read out, yeah. It does.
You said you were going to take us to the High Court enforcement officer regulations to show that there's a different regime in relation to.
That's right, my lord. You're right on time. That's exactly the point I raised.
That would be interesting. Yes.
So, in my submission, the High Court enforcement officer are appointed and operate under a completely different regime, and that's the High Court enforcement officer's regulations, as well as Schedule 7 to the Courts Act 2003. Starting with Schedule 7 to the 2003 Act, because the Courts Act was the legislation which led to the 2004 regulations. That can be found at tab 8.
Tab 8 is the regulations.
I apologise, my lead, that is correct. It is tab 7. In particular, section 99, which is at page 34. Where we can see that the definition there says Schedule 7 contains provisions about High Court writs of execution. We don't need to worry about warrants. And it also goes on to declare that any rule of law requiring a writ of execution issued from the High Court to be directed to a sheriff is abolished. For obvious reason, because we have a new functionary by way of a High Court enforcement officer, not a sheriff. But the key point there is Schedule 7 contains the provisions about writs of execution. I do not believe it's disputed or can be disputed that writs of execution includes a writ of control. Then we come on to Schedule 7, which is the page over. And in particular, paragraph 6.2 on page 37 says paragraphs 8 to 11 do not apply to any writ that confers power to use the procedure in Schedule 12 to the Tribunals, Courts and Enforcement Act 2007, but apply to any other writ of execution against goods which is issued from the High Court. And as I'll comment in a moment, the reason why there is that distinction is because under this regime, there is and I'll come on to paragraphs 8 to 11 now, the way in which the High Court enforcement officer can operate under a writ of execution against goods which is issued from the High Court that isn't subject to the procedure in Schedule 12 operates under a completely different regime to that an enforcement agent operates under.
Give us an example of a situation in which the procedure under Section 12 Schedule 12 would not apply.
It might be where High Court enforcement officer himself enforces the writ under those regulations.
Well, that's circular, sorry. Any writ that confers power to use the procedure in Schedule 12, well, the standard form writ, according to you, does confer that power.
Yes.
So, give us an example of a writ that wouldn't.
I wouldn't be able to know, Madam, my lady, off the top of my head, what
because we know that there's a few sort of leftovers, ecclesiastical writs and the like, that are referred to. And it may well be that the carve-out applies to those. Because what it says is it doesn't apply to a writ that confers power to use the procedure in Schedule 12. Now, on your argument, this writ does, and that's in standard form. So we've got some other kind of writ, other than the standard form writ of control, and then everything from paragraphs 8 to 11 relate to that type of creature, which is not the creature with which we're dealing. So I'm not sure that that is terribly helpful in terms of showing that a High Court enforcement officer has power under some separate regime to do what this enforcement agent did.
Submission I would make, my lady, and I appreciate it's not necessarily the strongest, is that the High Court enforcement officer, even if there is a writ that confers power to use the procedure in Schedule 12, it's the High Court enforcement officer himself that is executing that writ, then it would be under this regime.
But that submission does not make sense in the face of a provision which says paragraphs 8 to 11 do not apply to any writ that confers power to use that procedure. So once the writ confers the power to use the procedure under Schedule 12, you forget about paragraphs 8 to 11. And on my understanding of that, please correct me if you have a contrary submission, the High Court enforcement officer acting in person as a High Court enforcement officer could never use paragraphs 8 to 11 to enforce his powers under the writ of control.
My lady, I accept that. I'll move on swiftly from that point.
I think there are two types of writ that aren't covered by. They are writs of delivery, where there is no element of taking control of goods, and ecclesiastical writs. I think we see that from 83 PD 4.
Yes, my lord. I will move on from that submission. I appreciate it's not a strong one. Where these regulations and the Act do help, though, is in respect of whether or not High Court enforcement officer is exempt for the purpose of being an enforcement agent. Just so the court can follow this a little bit better, if I can ask the court to turn to paragraph 20 of my skeleton, that will assist. Page 116 of the core bundle. The submission was anticipated by my learned friend in his submission. And in summary, what we have is, under Section 64 of the Tribunals Courts Enforcement Act, we have an enforcement agent that is required to apply for a certificate issued by a judge of the county court. Practice Direction 84 sets out those requirements that my learned friend mentioned in his submissions. And of course, we've already dealt with the point that under paragraph 2.11e, there's a requirement for proof either that the applicant has achieved a level 2 qualification or has been authorised to act as an enforcement officer in accordance with the 2004 regulations. The word authorise being an important one. On that first submission alone, we can see that by being authorised to act as an enforcement officer, there is a shortcut to the requirement for qualifications. But that doesn't mean that the High Court enforcement officer doesn't need the certificate, because there's only one element of the equation under Practice Direction 84.
Well, doesn't it mean that he can get a certificate more readily than somebody else? If he wants one, it doesn't necessarily assume that he has to get one.
In my submission, the High Court enforcement officer has to get one, but it is a more readily, it's a shortcut because you don't need the qualification, but he still needs to get the certificate from the county court. That's what Practice Direction 84 requires. And we have some supporting, and I appreciate that the White Book commentary cannot always necessarily be correct for the reasons the court alluded to earlier. But paragraph 83.0.5 of the White Book, again, it's within the authorities bundle. Page 633.
83 point...
0.5. Page 633. It is somewhat the way down, the fifth sentence down. It talks about the Take Control of Goods Regulation 2013 because, of course, this part of the CPR, Part 83, deals with those regulations in particular. But it says, the Take Control of Goods Regulation 2013 will mean that an enforcement officer may only be able to enforce writs of control, which will still be issued in their names if they are certificated as an enforcement agent under Schedule 12. So they still require certification. Of course, as a general point, the 2013 regulations supplement Schedule 12 and provide details behind its exercise. It talks about things like the modes of entry, methods of securing goods for sale. But it supports the point that there is requirements for certification by the enforcement officer. Supporting that is my second point, paragraph 21b. 20b of my skeleton.
This is the distinction between appointments and authorisation.
That's right. Yeah. So we have, and the distinction will be proved in my submission on what paragraph 12 of the of Schedule 12 of the Courts Act says. But I'll get to that in a moment. So We have Section 2.1 of the 2003 Act that refers to the appointment of officers and staff. Appreciate the point my learned friend is who could that be if not a High Court enforcement officer? But putting that question to the side for a moment, we have paragraph 2 of Schedule 7 to the 2003 Act, which governs, and my learned friend pointed the court out to this, which governs the authorization of an individual to act as the High Court enforcement officer. But in support of that, we have paragraph 12 of Schedule 7, which can be found at page 39 of the authorities bundle, page 39 and 40. Which sets out that the Lord Chancellor may make regulation for the purpose of giving effect to the provisions of this schedule that relate to enforcement officers. Then further on, so paragraph 2, the regulations may in particular make provision as to the conditions to be met by individuals seeking to be authorised to act as enforcement officers. Therefore, it's an authorisation, not an appointment under Section 2.1. In my submission, that's plain as day, based on particularly what paragraph 12 says.
But it is a fair question to ask. I know you parked it, but who is it anticipated that persons appointed under that section is referring to? Then
it does there state under Section 2.1 officers and staff. It is hard to envisage who it could be. But the provision is there, whether it's a provision that's OTOs in some way.
Well, we know that it is referring to appointing somebody in connection with enforcement through a writ of control. And we know that the person to whom a writ of control is, in the standard form, directed is a High Court enforcement officer. And we know that there are regulations concerning the authorisation of HCEO. It isn't the argument I would put to you is, isn't it possible to purposely read those together to say that what is being referred to there is the authorisation of an HCEO
under Section 2.1.
Yes.
The argument is there, in my submission, it doesn't accord with what I have said in terms
because it says authorisation rather than appointment.
We start from section. Start from paragraph 2 of Schedule 7, which governs the authorisation of an individual to act as a HCO. Then we have paragraph 12, which talks about the conditions to be met to be so authorised. It doesn't there reference anywhere within those two provisions that it is an appointment by the Lord Chancellor under Section 2.1, i.e. in relation to officers and staff of the court for the administration of his duties.
Isn't there something, just standing back though for a second, isn't there something rather remarkable about a structure in which standard form writs of control are issued to authorised persons throughout the country, one for each district, expressly empowering them to seize goods. But you say, because of the wording of the regulations, those persons do not themselves, despite the fact they're called enforcement officers, have the power to enforce. And the easy answer to it is that because they're appointed as enforcement officers, they do have the power to enforce, as one would expect, as a matter of common sense and logic.
There is a power to enforce to that extent, but it doesn't come from Section 2.1. It's the authority drawn from the Lord Chancellor as opposed to an appointment of a High Court enforcement officer. That's the way in which
the authorisation to act as the High Court officer comes from the Lord Chancellor, but
yes.
the power to act as an enforcement agent comes from Section 63. Section 63. 2 or 3, is it?
Yes. No. Section 63.
I mean, I agree. It all does require a little bit of unpicking But I think reading these rules reading the sections and rules so as to come out with the result that a High Court enforcement officer cannot enforce is, if you don't mind me saying, fairly bizarre.
I can also see that if you authorise somebody to act in a particular capacity with the rights and powers and duties of such a person, you can equate that authorisation with appointing them to that role without doing great violence to a statute.
Well, my alternative position, given the query by the court, is if the court was to find that the High Court enforcement officer, that the writ confers the enforcement power on the High Court enforcement officer, therefore he does have the power to enforce. In that situation, this would make sense in the sense that they would still not be considered exempt under Section 2.1, but to act as an enforcement agent, they would still need the authorisation of the Lord Chancellor. They couldn't be appointed. They can enforce by using an enforcement agent, but to be authorised to act as a High Court enforcement agent, they would need to get authorisation from the Lord Chancellor under the provisions that I have just mentioned, as well as get the certification from the county court.
That's the position that is taken, I think, by the commentators in the commentary that you showed us.
Yes.
They need the certification if they want to do it themselves. If they don't have the certification, they've got to go through an enforcement agent.
I appreciate my lady, yes. The commentary does say that.
Yes. Can I just, it takes you out of your course. I'm conscious that time is running on, but at some point, no doubt you were going to say something. Mr. Williamson seems to be taking off his own bat a position remarkably different to that of his association. Is there a reason for that? Why does he want to take this? Well, not why does he want to. Why is his position so remarkably different from the association?
I can't really step in his shoes and explain the necessary reasons why I've not, of course, spoken to him into that sense of why he's done this. All I can say is, based on my instructions, that he believes he's correct based on the way in which I've interpreted the legislation. So he's approached it based on the wording of the legislation, the regulations, and how it all fits in together. But I cannot say anything further than that.
Yes, well, you're right to say that his motivations for taking stance aren't relevant, but it is obviously interesting that he seems to be out on a limb on this, you say.
Within his witness evidence, it's made very clear that he considered that he had no entitlement to the fees, which is the position I hold, that he didn't have the entitlement to the fees. It belongs to the enforcement agent.
Are you going to address this on the bank account?
Yes, I am. If you would like me, if your lordship would like me to address,
No, you take your own course, but obviously we'll
be
need to
addressed.
move through the points quite quickly.
I'll move through that. So that's that submission. We've dealt with the principles of agency. We come on to vicarious liability. I do believe it's the position of vicarious liability. Paragraph 60. So there's 3 more points to be made, and I'll move on to the bank account point. Paragraph 27, my skeleton onwards. My learned friend's position is that the pre-Tribunals Courts and Enforcement Act position was the sheriff, now called a High Court enforcement officer, held either a non-delegable duty, duty of care, and/or was vicariously liable under the ordinary principles of the common law for the actions of bailiffs, now enforcement agents. I don't dispute that was the common law vicarious liability position, the way of which I've worded in my skeleton argument. However, my learned friend suggests that the common law vicarious liability position hasn't changed post the introduction of the 2007 Act, and that it extends to the fees charged, or at least an 84.16 application for an assessment of fees. Paragraph 28 of my skeleton, in a nutshell, goes through the various cases that my learned friend referred to, as well as Professor Atia's book, Vicarious Liability in the Law of Torts, as it applies to sheriffs and bailiffs. But one can see that that vicarious liability in most circumstances, apart from 2, which is referred to in the authorities bundle in a moment, applies to tortious conduct. So we see that Professor Attia states that it's a very old rule indeed that a sheriff is liable for the acts of his officers in wrongful executions. And then my own friend relies on a number of different cases. First is Smith and Pritchard, involving trespass, breaking and entering on the part of the bailiff. Bates and Pillings and Seddon, trespass is again the cause of action. In situations where one has wrongfully executed the writ in wrongfully detaining the goods. And then Hooper and Laing, where the judge in that case stated that the sheriff is responsible for the acts of the bailiff done in execution of writs, and gives secure redress against any illegal act. And my other friend referred to the case of Watson as well in that respect. In particular, I believe it's page 235 of the authorities bundle, which is states. The proposition was yes, at the bottom of that page. In that case, the first alleged breach of duty on the part of the sheriffs was that they had wrongfully seized goods of the plaintiff of greater value than sufficient to pay the debt. And I believe, unless I'm mistaken, I'm sure my lady, Lord Justice, Lady Justice Andrews will tell me, is that there is clearly an alleged breach of duty. So a breach of duty, of course, is a tort, but it applied where there was a situation of a wrongful levying of fees. But when one reads what is said in the judgment there, is that it's in relation to wrongfully seizing goods of the plaintiff of a greater value than sufficient to pay the debt. Not a situation where there's been a miscalculation of what the fees are, which is what happened in this case.
Two go hand in hand, because if you haven't seized the goods, there's nothing from which to levy the fee.
I appreciate that. In this case, what happened was that there was a £500 credit to be given based on the fact that the writ itself had not set out the correct value of the judgment debt. But what I will say is that when one looks at a fees assessment application, it's only that. It's a fees assessment. It's not an application for damages. It's not an application where any civil liability arises. It's a form of detailed assessment in my submission.
Does that mean that if there is hypothetically tortious activity of that nature, so the enforcement agent seizes goods which are obviously well in excess of the value that he's executing for, let's say, for example, but there is also a dispute in relation to the fees that he's charging, you'd have two separate processes for redress.
Yes, my lady. And that would be because we have paragraph 66.
Yeah.
But this was not a paragraph 66 application. It was a paragraph 62 in effect, an 84.16 application.
So you don't shirk from the proposition that if you are right, and there is, and contrary to your other submissions, there would be vicarious liability of some kind for tortious activity, that would have to be pursued by way of some separate action from the claim in relation to the assessment of the fees.
If there was a relationship of vicarious liability, that I couldn't get away from that. That's where the respondent's notice comes in. It's the definition of what a related party in the paragraph 66 is. In my submission, that, and it's partly based on what I've already said before about the conferral of authority. It cannot be the enforcement officer, but a key distinction there is in Schedule 12, in paragraph 62, or within 2014 fees regulations, or within the civil procedure rules, there is no related party definition or someone else that can be involved. What we do know is there's references to an enforcement agent, one would have thought, in the same vein as a paragraph 66 application, there would be a reference to a related party if there was to be someone else to be involved. It's significant that that provision is there for one type of application, but it's not there for another type of application.
And presumably, as happened here, you could list, if two sets of proceedings are required to ventilate that kind of dispute, you could list the two together in front of the same judge.
And that's completely right, my lady. You could list the two applications together. This is not an appeal about, that's not what happened in this case. This case is all about Rule 84.16, a fees assessment application. I appreciate the time available. I'll have one more point to raise in respect of vicarious liability, is in respect of whether or not there's a vicarious liability relationship at all, or whether or not there's some form of non-delegable duty of care involved in this case. My learned friend mentions the case of Cox and BXB as setting out the usual test for this. If I can draw the court's attention to that. The Cox can be found at 344 onwards. And I should say it's page 351 to 352 that sets out the test. Apologies, I don't believe those are the factors.
So where are we looking?
I have just lost the particular test I would like to, but it says it in the note anyway. It's at page 344. The essential factors, and I'm sure the court is aware that it is trite law, what the test is following Cox. The essential factors of the tort committed as a result of activity being undertaken by the tortfeasor on behalf of the defendant. In my submission, the activities of an enforcement agent are not conducted on behalf of an enforcement officer. Whichever submission, whether it's my primary case that there's no conferral of authority or conferral of enforcement power, or otherwise, because both individuals are officers of the court, they're acting on behalf of the court. There's no activity being undertaken by the enforcement agent on behalf of the High Court enforcement officer. They're conducting their own enforcement powers under Schedule 12.
And you don't read anything into the fact that the term agent was used?
No, my lord. I appreciate the word agent is used, but it's an agent of the court than an agent of the High Court enforcement officer.
Well, is that right? The clear wording of the provisions are that the agent has to be authorised by the person upon whom the power was conferred. So the person whose agent they are, from whom they get their authority, is the person on whom the power was conferred.
Lord Legate in CES suggested it was that an enforcement agent, as well as the High Court enforcement officer, is an officer of the court. Therefore, in my submission, is an agent of the court, not an agent of the High Court enforcement officer. It says at paragraph 122 of that judgment, for your reference. Yes, of the.
I'm so sorry, it's my fault. Which judgment are you referring to, Mr.
It is the Court Enforcement Services and Master Legal Services, the Bellagio judgment, as it's called. It's on page
47. Lord Legate is saying that the an enforcement agent is an officer of the court. I don't think he's saying it's an agent of the court.
Well, if your lordship looks at the reasoning there, the judge states the essential reason is that the enforcement agent is acting at the direction of the court to enforce the judgment order of the court, exercising authority conferred by the court's writ. So,
Yes.
So in my submission, an enforcement agent, as well as an enforcement officer, is acting at the direction of the court. Because in my case, the writ confers the power. The writ is directed to the enforcement officer, and the writ comes from the court.
But it doesn't stop him acting under delegated authority of the High Court enforcement officer if you're wrong on your principal argument that the High Court enforcement officer has no power.
Well,
He can be both an officer of the court and acting as somebody for whom the HCEO is vicariously liable.
in my submission, that there would be a conflict potentially between the two different types of authority in that situation.
Well, what you've got is a statute which specifically preserves the pre-existing liabilities of sheriffs for the acts of bailiffs. It does so in express terms.
Well, my lady, it's subject to Schedule 12. It's preserved to the extent that there is. It's preserved, but it's subject to Schedule 12. So now, by way of the introduction of Schedule 12 and the enforcement agent's ability to proceed under it, which gives a debtor his own remedies under paragraph 66, or a fees assessment with 84.16, that's the new regime under which it operates.
But the whole reason pre-statute for requiring the HCEO or the sheriff, as it then was, to be responsible was a public policy consideration. It was intended to act as a fetter on rogue agents from going off and doing their own thing, seizing goods and whatever, rampaging. The salutary requirement is that the HCEO is brought to book if they go off and do that. And I can see nothing in Schedule 12 that says that in the matter of parliamentary policy, it was decided to get rid of that simply by providing a new mechanism by which to enforce. Those policy considerations still are writ large, because there's still the temptation for an enforcement agent, suggesting it happened in this case, but you've got to look wider, to line his own nest.
Well, of course, my lady, I've already referred to paragraph 42 of Schedule 7, which preserves those rights, privileges, and liabilities of a sheriff, subject to Schedule 12, as already mentioned. We also have Section 65 of the Tribunals Courts Enforcement Act. It says this chapter replaces the common law rules about the exercise of the powers, which under it become powers to use the procedure under Schedule 12. And then we also have Lord Legat at paragraph 22 in the same judgment, Bellagio, where he says, by a combination of those two provisions, paragraph 4 of Schedule 7 and Section 65 of the 2007 Act, combined effects unequivocally that the exercise of the power to enforce a writ of control is exclusively governed by Schedule 12 and not by the common law. What I would submit is that the new regime has a mechanism which only allows the debtor to pursue the enforcement agent, because it's the enforcement agent who has the power to proceed under it, not the High Court enforcement officer. There is a new type of regime which, in my submission, doesn't involve vicarious liability. But I appreciate the concern, my lady, that you raised as to whether it has changed. In my view, it has. But in any event, going back to the principles of vicarious liability very quickly, back at page 344.
Well, really, the leading case is the Christian Brothers case, not this one. Cox just simply reiterates it. The issue is whether it's fair, just and reasonable to impose liability if there isn't a contractual relationship.
Yes, my lady. Well, just reiterating those principles set out, I would say it's not fair, just and reasonable in the circumstances where there is a new schedule in place. But applying the test, that the activity was integral to the defendant's business activities, and that the defendant, by employing the tortfeasor to carry out the activity, created the risk of the tort being committed by the tortfeasor. Well, the activity of enforcing under Schedule 12 is not integral to the defendant's business, because they cannot on the ground work under Schedule 12. So I cannot see how it's integral to the defendant's business activity at all. The reason set up my skeleton, one cannot say that there's a sufficiently close relationship between the enforcement agent and the High Court enforcement officer for the submissions I have already made, or akin to that relationship. The key point being that a HCEO cannot control the activities of an enforcement agent, because it's only an enforcement agent who can exercise powers under Schedule 12. So a High Court enforcement officer cannot tell the enforcement agent what to do, when it's only the enforcement agent who can exercise those powers. So for those reasons, in my submission, vicarious liability doesn't apply. And then very quickly then, there is also the question of non-delegable duty, which follows on paragraph 31 of my skeleton. And this takes from Clark and Lindsell on torts. For a party to be held liable on the basis of non-delegable duty, he would have to be in breach of some duty which he personally owes to a claimant. In this case, the judgment debtor. And that duty would have to be a tortious duty to take reasonable care, which that party has assumed responsibility for. So we're looking at the fees application alone. There is no personal duty on the part of an enforcement officer to make sure that the enforcement agent, in relation to his own fees, in respect of enforcement-related services that he provides, there's no duty to ensure that those fees are correct. And in any event, such a duty, where there's a misapplication of the fees regime, cannot be seen as a tort in any event. It's simply an assessment of fees for reasons I mentioned earlier.
Do you dispute that it's a breach of statutory duty?
In my submission, if there were, to be considered a breach of statutory duty, the application would be one that has to be made in paragraph 66. As in my submission, yes, to a degree, if there was a wrongful execution of goods, so you take too much, as opposed to simply getting it wrong in terms of how much you can recover from it, then, for example, if you sold goods at a higher value, then you could see, yes, an argument to be made under paragraph 66, but not in respect of a fees assessment application, where the court has simply been directed to assess what those fees are. So that is the dispute in question. What are the correct fees?
I suppose the point about the tort of breach of statutory duty is that not all breaches of a statutory duty will found tortious liability. And there's quite a lot of complicated law about that as well, isn't there?
Yes, and there has to be civil liability, my lady. That's correct. There has to be civil liability attached to it.
Well, that's
There's
another rabbit hole, potentially. All right.
And no civil liability attaches to a fees assessment application. There's no liability for damages.
So, were you going to come on to do with the bank account point, or are you still on non-delegable duties?
I'm very quickly, I'm conscious of time. I have two more points to make, and then I can move on to the bank account point. Those 2 points which are very short. Moving on to the concept of related party in the paragraph 66, I don't believe I need to say much more. The reference in paragraph 66 in respect of a related party refers to
Well, it follows from your argument on the earlier part, doesn't it? Because you say that
Yes.
The enforcement agent doesn't derive any authority from the enforcement agent.
And for those reasons, they're already set out. Those exact same reasons set out in the SCETA. I don't be able to address the court on that. Just double check. I don't have to. And then finally, the position in respect of the fact that the common law vicarious liability position has no bearing on a fees assessment application anyway. In a summary, alluded to it a bit earlier, is that the fees assessment application is simply a request by the debtor to assess the fees charged by an enforcement agent for the enforcement-related services they've provided, not a claim for a breach of a tortious duty of care, but in any event doesn't give rise to civil liability for damages. That would be a separate type of application to paragraph 66. So in any event, whichever way we look at it, in terms of regulation, in terms of paragraph 62 of Schedule 12 in conjunction with 84.16, there's no basis for holding a High Court enforcement officer vicariously liable for an assessment of fees. Does not appear to make sense on the proposition that I hold that the fees belong to an enforcement agent alone. But in any event, even if the enforcement agent isn't the one, even if those fees don't necessarily belong to him alone, the position still stands. Vicarious liability doesn't fall within the picture when it comes to a fees assessment.
No. You say on the proper construction of the statute, the only person from whom, against whom there'll be a dispute about the amount of the fees is the enforcement agent, irrespective of whether he keeps some of the fees for himself, passes them on to somebody else, or they include the collection of the auctioneer's fees as well.
My primary submission would be that he is the one entitled to the fees, my lady, but my secondary position would be, irrespective of who takes it, at the bottom of the chain, the one who's actually done the work on the ground under Schedule 12 is the one who would be a party to that application, because essentially
It doesn't matter whether he's done the work or not. On your analysis, Schedule 12 simply speaks of an enforcement agent, and therefore that's the person with whom there's going to be any sort of dispute about the fees that are recovered.
That's right, my lady.
And therefore, it's all very simple. You just look at Schedule 12, it's a self-contained regime, and if the debtor says that the money he's paid over, that he's taken too much money, then he has a gripe with that particular agent and with nobody else. That's the very simple way of looking at it, which is that Schedule 12 is self-contained.
That's right, my lady. I couldn't put it any better than that. That would be my secondary position to the first, which is he does take it, it's his. But in any event, he's the one who's taken it. Therefore, he's the one who should be ordered to pay it back if there has been a miscalculation or a misapplication.
Now, that's all very clear. But what if the money is sitting in the HCEO's bank account?
As on one view, it should be.
My primary submission is the one I started with at the beginning of my submissions, which is it doesn't sit in that account for the purposes of the enforcement agent's collection. In this case, it was DCBL.
Yeah. Can you help us? Can you help us with where the money should be?
In my submission, it should be in an account held by the enforcement agent or his agency.
I know you say that, but can you give us chapter and verse why you say that?
So we obviously have the national guidance, which I appreciate isn't entirely clear on the definition of an enforcement agent, but it clearly makes clear that the definition of an enforcement agent includes an enforcement agent himself. It refers to an enforcement agency, which in my submission is DCBL in this case. So there's no reason why those monies can't be put into an account held by DCBL or any other enforcement agency or any enforcement agent. Just because the High Court enforcement officer is required to hold a bank account to hold monies in doesn't necessarily mean that it must sit in that account.
Well, why not? What's the purpose of having it if it's not there
Yes.
for that purpose?
What would go in the High Court officers, on your analysis, what would go into that account?
Well, of course, it would be the proceeds if that's the way in which they do
I'm
it.
sorry to interrupt. Can you just remind me which provision deals
Yes.
with the HCEO's bank accounts? I think it might be helpful. to
Regulation.
Thank you.
Some Regulation 8 of the High
Yes.
Court.
Page 49.
Page 49, yeah.
Says every enforcement officer is under a continued duty to hold a bank account through which money is recovered and behalf judgment to be collected and paid. The duty is to hold the bank account. It does say that through which money is recovered on behalf of judgment to be collected and paid. But in my submission, there's no reason why it has to be in that account. It can be an account held by the enforcement agent as well, which
But can I
appears from the
ask-
guidance as well.
This is, I think, goes to the real heart of what we're talking about here. From what I understand, your submission is that these High Court enforcement agents are appointed up and down the country, but when writs are sent to them, they have absolutely no role in the exercise, other than merely to instruct an agent. They don't have themselves any power. They can't collect any monies. All they do is instruct an agent. So the provisions in Regulation 8 to have training, have professional development, have insurance policies, and again, they're not vicariously liable, so why do they need insurance policies? Hold a bank account, produce audited accounts, performance statistics, and relevant to his work as an enforcement officer. But on your contention, there is no work as an enforcement officer. They don't do anything at all.
Although I wouldn't say they do nothing, of
Well,
course.
what do they do? Can you tell me what, on your case, does a High Court enforcement officer do?
Well, of course, it instructs the enforcement agent. Of course, there is some form of, under the relevant guidance, is some form of supervision element in terms of that. But
I know you've said that there's no supervision element. You said they can't tell the agent to get up on a Monday.
yes, I appreciate it, my lord.
But forgive me, I want to put this to you really starkly. On your case, a High Court enforcement officer has no obligation, no liability, no right to anything at all, other than to instruct someone to act as agent, and possibly, as a term of that instruction, to be paid back a fee by the agent. And that is their entire role, from what you say.
I appreciate it, my lord. Yes, that's based on the reading of the legislation, as I've made clear. Yes,
I understood that right. That is your case.
Yeah.
Mr. Williamson, all Mr. Williamson has to do all day when he receives a writ is instruct an agent, and that's it.
yes, because under Schedule 12, the person who does all the work is the enforcement agent, who's
So
the fees are payable.
he really doesn't need any insurance. He really doesn't need to carry on any sort of continuous professional development, because there's no professional development to continue. And there's no point in his holding a bank account through which money is recovered from the judgment debtor could be paid back to the judgment debtor if they're surplus to requirements, because the enforcement agent will do it all for him.
My dear, what I will say is that there are, of course, other types of writs, as we mentioned earlier, that the enforcement officer, under the same regulations, under the Courts Act, that the enforcement officer will be working on in his own right.
Ecclesiastical writs and
Writs of delivery
when there's no taking control. Well, there we are. That's very. If you don't mind saying, that's really helpful to get it clarified. That is your case, and we have to consider whether that could be what the overall intention of these provisions is.
It would appear that 8D, in most circumstances, given the effect of Schedule 12, is probably not a requirement anymore. It's still sat there again. Ultimately, it's OTOs.
Yes. I'm conscious. Do you want? Have you finished your main submission? Because I think we really do want to hear from you on the consequences if you're wrong in relation to
Costs.
the costs.
Yes, that is my next point anyway. So I can move on to that. So this is set out in paragraph 48 of my skeleton, the basic principle.
I think your preference is that it should go back to the master, isn't it?
That's right.
But the problem with that is that it's just going to create another round of costs.
I appreciate that, my lady. Would argue that the master's in the best position, given the background to the matter, given the decision made in respect to the totality of the case, to be able to exercise that discretion afresh. With all due respect to the Court of Appeal, the Court of Appeal is in a much more difficult position to do that, because the full details of the case, the background to it, the evidence, is not available before this court. And it's ultimately the first instance judge who exercised that discretion. So I would say in the first instance that it gets remitted back. We
know that your client throughout took the position that it wasn't properly a respondent, and if we find against you on that, then arguably Mr. Brown and the company would never needed to have been joined, but for that contention, and it seems to me that it must follow, mustn't it, that the costs in relation to the fee dispute should be Mr. Bones as against your client. That would follow as well, wouldn't it? The big question is what happens about the final hearing in February 2021, when by that stage the fee dispute was over to the extent that the fees had been waived and no damages were recovered. Isn't that the real outstanding issue?
That's right, my lord. At trial, the damages claim did not succeed. At that point in time, the fees assessment application had fallen away, and the court made an
But the question of costs of that was still outstanding, wasn't it? Which you were still maintaining that you shouldn't have been a respondent. That was argued and determined at that hearing.
It was.
So on the assumption that going back to it, you would have lost that on this hypothesis, then there had to be that hearing.
My submission, no, because the hearing would still have had to go ahead because there was still the damages component still left to be determined.
Yes.
So irrespective of where we are, the cost would still have been incurred to attend that hearing.
Well, but that brings you the other way around. The cost would still have been incurred because you would still have had to argue your point about not being a proper respondent.
I appreciate that, my lord.
And what about Mr. Brown? Mr. Brown got his costs, but he was only there because of your position.
Bear with me, my lord. I do have my points on.
Yes,
the
sorry.
section.
Just slightly trying to summarise it so you can focus on perhaps what we need to hear from you on.
I mean, the only point I can raise in that respect is there's no appeal against Mr. Brown's cost order in favour of Mr. Brown. That's the first point. That's not been raised until today.
No, your opponent says, I accept that there's no appeal and I can't go behind that, but what I want is a Bullock order or a Sanderson order to make your client, Mr. Williamson, defray those costs which I've had to pay to Mr. Brown, on the basis that Mr. Brown would not have been involved if it hadn't been for your client taking the wrong stance, that he shouldn't have been made a party.
The best way to look at it, my lady, is there was a ground that was to be ventilated before the first appeal judge that wasn't ventilated for reasons that she found in favour of my client. But in the event that she wasn't to, there were submissions ready. I can turn your attention to it. That's the starting point in terms of the court's queries. It's in the core bundle. I believe it's appended to my respondent's notice, page 93 onwards, tab 11. It's page 102.
Yeah. Well, we've obviously read this with some care.
Yes. My submission, the key point really is, of course, I appreciate the court's read this. I do not intend to go through chapter and verse on those submissions. They are there in respect of the position that the cost order should remain the same as long as in respect of the costs awarded in favour of my client. But we also have to look at the offers that were made prior to that hearing. They're set out at page 104.
Yeah.
What we have is a £5,000 full and final settlement offer that was made on 18th of December. Now, on the 17th of December, that was the date by way of telephone call that Mr. Brown was confirmed that the fee that he would be remitting the fees. And in fact, £5,000 was more than the issue of fees in respect of that application. They came to 4,753. The appellant at that time argued that that didn't apply. So even taking that into account, he was getting more than what he bargained for at the time. But that was not accepted.
But that was an offer to pay him the enforcement, that £5,000. But we don't know what the costs were, do we?
No, I don't have.
And that's why it's difficult to assess the merits of it.
I believe it was refused on the basis of costs.
Yeah.
But the offer was made there. There were further offers made down the line, 21st of December. The enforcement fees would be remitted.
Well, we do know what the difference is between 4,753 and 5,000.
Yes.
And we can take an educated view as to whether that would be sufficient to cover costs at that stage.
And further offers were made down the line as well.
I think it would be helpful if we had a cost schedule from the court below.
I believe we do.
And it is in the supplemental bundle.
I thought it was.
And tab 19 is the appellant's.
Yes.
No, that's wrong.
But that's the
So
first
that's
appeal, it's
appeal.
the hearing, it's 18, isn't it?
Thank you.
Tab 18, I think.
Yeah.
Little over 16,000.
Yeah.
My lord, two submissions with respect of cost that I can make, aside from what the ground 3 set out, is I can't really get away from the fact that if court was fined against me, there would be an element of cost going the other way, because ultimately Mr. Brown has ultimately the point could be resolved at the beginning, essentially. But it would only be in respect of costs in my submission running up to the point at which Mr. Brown came in and gave the money back. It shouldn't be any further forward than that. And on my client's case, that's 6th of January 2021. But I'll actually say that there is an argument to be made that it should be earlier than that, on the 17th of December, when the decision was made that he would be giving the money back. 17th of December 2020. So the period would be 18th of September 20 to 17th of December 20. My second submission would be that those costs should only be in relation to the fees assessment element. It wouldn't be in respect of the damages claim, which carried on until the hearing in February of 2021. But of course, that's in terms of determining what that would look like, that would be obviously an assessment of costs. The cost schedule that has been provided by their friends solicitors doesn't break down the costs at all. And in respect of Mr. Brown, I appreciate that his involvement was that he was involved as a result of the fact that he was involved for the fees assessment element, and that he ended up paying the fees back. All I can say, he was involved because it was the decision of the appellant to add him into the proceedings. So I don't see why, in my submission, my client should be held responsible.
Well, because if you hadn't said I'm not the right defendant, respondent, you wouldn't be added in.
Well, then, if there was confidence,
scenario, isn't it, where if you say I'm not liable, somebody else is, if they're then added in, and you prove to be wrong, you may find yourself liable for those costs.
But they could have had confidence. The appellant could have had confidence that that was not the case. They decided to bring Mr. Brown in. They didn't have to. They did it off their own accord, simply because the argument was made that simply because the argument was made that we're not the right person, didn't necessarily mean that they had to agree with it and get Mr. Brown in. It was their choice in my submission. So that's my position in respect of costs, or the principle of costs.
Thank you.
I'll just double check there's nothing further from me.
And you can make the point that in the appellant's notice, the order that was being sought, page 8 of the core bundle, was that Mr. Williamson to pay Mr. Bones' costs of the application and appeals. Whether that encompasses Mr. Bones' liability for Mr. Brown's costs might be a matter of some debate.
Yes, my lord. The reversal is simply one reversal, i.e. to reverse the cost position as it relates to Mr. Bone as against Mr. Williamson. The grounds of appeal did not at any point in time, the first we're hearing of it today, seeks a separate type of order.
Thank you.
Thank you, my lord. I'll just double check there's nothing further from me. Nothing further from me.
Give me. Thank you, Mr. Kessler. Obviously, you've heard that. I'm sorry. I was going to say you've heard that we did test out Mr. Trivedi's contentions quite significantly during. So it may be that you'll tailor your reply in that context.
Yes. Thank you for that indication, and I do hope the court appreciates that. I hope it doesn't feel that I overstated the point in my opening remarks that this is ultimately an appeal about whether an HCO has a job or not, whether their bank account is purely out for an ecclesiastical writ. But anyway, I have 4 submissions and 2 points of housekeeping. I might do the housekeeping first. During my opening submissions, my lady, Mr. Justice Laing, asked whether Ms. Hughie's skeleton argument contained any references to the HCO Association's guidance in the context of costs, and I confirm they do not. And the other point was whether we could prepare my own friend and I prepare an agreed note on the use of explanatory materials. Both sides have relied on explanatory materials. I'm somewhat hesitant to do so because it's not a subject in which I have much expertise. I have printed off a chapter from Bennion on statutory interpretation. I could hand it up if it would be useful. The bottom line is that explanatory notes to an act may be used to understand the background to and context of an act, but only if they're publicly available.
Yeah.
If it's helpful, I can hand it up. I don't think there's anything new in there, and this is not an appeal about Pepper and Hart. So I might leave it there.
Does that chapter in Bennion, I can't remember now, whether it draws the distinction between explanatory memos and explanatory notes?
That's a fair question.
Because a memo, as I recall, if it's laid before Parliament, is actually there to explain to the legislators what the intention is at the time. And a note is something which generally you wouldn't look at unless there's an ambiguity or a contextual issue that needs to be looked at.
So in this particular passage, that distinction is not drawn.
Right.
But I'm not saying that distinction isn't there. This is not subject matter which I can
You can have a look at Bennion.
I mean, if you've got copies,
I do.
by all means, hand them up to you.
I went up to your usher. Out. So I have 4 quick submissions, one of them about ground 1, the central question, and 3 of them around costs.
Thank you.
Now, my only submission on ground 1, I'd like to ask the court to pick up the authorities bundle and turning to tab 9, page 5, section 62. Subparagraph 4 renames a writ, and my Latin might be wrong, of fieri facias, except for ecclesiastical writs. And it renames them writs of control. And the reason I mention this is because if the court then takes up the standard template, sorry, the writ in this case, which the court can take on submission, comes from the standard template in the supplemental bundle, behind tab 2. The court will see that at the very top it is a writ of control. Yeah. So this must be a document that postdates the 2007 Act. Though the language is somewhat antiquated, it has been amended in light of that Act. That's a very quick submission on the substance. 3 quick submissions on costs, bearing in mind that night is drawing in. The first is the question of remitting the cost decision back to Master Sullivan. I say there are public and there are private reasons why that shouldn't be done. The public reason is I say that there is a wider principle at stake due to the conduct of the HCO in these circumstances, and it's important that this court addresses that. The private reasons are that this hearing before Master Sullivan took place almost 3 years ago. It will be 3 years if the court reserves judgment. I don't think the court is in any... Master Sullivan will be in a better position, I doubt she'll remember. And I don't think it's fair for Mr. Bone to wait any longer. My next penultimate submission relates to the respondent's notice, which you were addressed just now, and I didn't take you to in my submissions. Respondent's notice in the core bundle. Now, I have a technical point about this and substantial ones. The technical one is it would be accurate to describe this as the respondent's notice in the High Court. It's not a respondent's notice filed in this court. The respondent's notice in this court raised the section, paragraph 66 point, and made arguments about Singh and Das, and Mr. Bowen raising new arguments on appeal, which apparently aren't being pursued. And it's a respondent's notice only in the High Court that makes these points about costs. But I would like to address them.
Oh, I'm sorry. Page 102. I hadn't realised that was the High Court.
Yes.
I'm sorry. I thought. So it's the respondent's notice in the appeal.
On the first appeal.
On the first appeal.
On this appeal, I see.
And it hasn't been repeated. It's a technical point, purely technical point, but I place some weight on it. I would also dispute the substance of this respondent's notice, and I thought I might just go through paragraph 3 and give the answer on behalf of Mr. Bowen briefly. 3.1, Mr. Bowen lost in his damages claim. We discussed this point. I accept that he wasn't successful, but I would argue neither was Mr. Williamson. Mr. Bowen's conduct, just before I address the criticism of my client's conduct, I do say there's some disparity between my client, who's a private citizen, and an officer of the court who can and must be held to higher standards. But let's look at this. There's an alleged failure to comply with Master McLeod's order by not giving notice to the judgment creditor. Well, I'm not sure that is significant in any way. The hearing on the 4th of November 2020 was for directions, probably because the creditor had not been given notice. I think that's a slightly disingenuous submission. The reason directions were given was in order to add Mr. Brown and DBCL as a party at Mr. Williamson's request. My client wanted the hearing to take place that day, and it wasn't. And we've been discussing why the whole time. The appellant failed to say anyone about the hearing for Master Sullivan. I'm not sure what I can say about that. The allegation is that parties incurred costs working out what had gone on. That's pretty unsubstantiated. I'm not sure that's any grounds to change the usual costs order. 3.2.3 criticises the evidence given in the application for damages. The consequence of that is the application for damages was dismissed. And the consequences will flow from that dismissal, but I'm not sure that could be a separate ground for conduct.
Same for 3.2.4.
The same from 3.2.4, and I don't accept the submissions were inappropriate or disrespectful. And the same for 3.2.5. A scribble that could be made by a postman perhaps cat.
Facetious.
Yeah.
Facetious, perhaps colourful, but to not award someone costs.
I don't think you should spend time on that.
No.
Then moving on to the offers, 3.3. Well, the first offer was beaten, and it was beaten because the offer was for £5,000, and the costs and fees conceded were for £5,703. 3.3.2 is the notification enforcement fees were paid, or that's not an offer. 3.3.3 and 3.3.4 are both drop hands offers. So I'm not sure how much weight the court can put on them. The court will have to decide what's the correct cost order, and if the order is anything but no order as to costs, then those offers won't beat. So I'm not sure how much weight can be placed on any of these factors in the first respondent's notice, even if the first respondent's was allowed. And the very last point is in response to my own friend's submission that my client chose to add Mr. Brown. He had it wasn't an option, it was an order of the court made at Mr. Williamson's request. And I will show the court the order because it's the order that adds them. Of course, my client has no ability to add someone to a party, only the court can, because it could amend, but that's not what happened. One sees this behind tab 9 on page 94 of the respondent's bundle. Following joint respondents, Mr. Brown and DBCL. So it was not a decision, it was a decision made against my client's will. My client is all the time in an application against one respondent, and that respondent is the each CEO. The reasons I've given, I split that with the
Yes.
Unless there's anything else I can assist the court with. That concludes my submissions.
I see that DCBL were only joined for the purposes of disclosure and service addresses,
Yes.
so they didn't play any substantive part.
No.
Thank you very much. Well, thank you to both parties for a very interesting argument. We will reserve our judgments, and they will be provided in draft in the usual way to the list of parties for circulation. You're now, I'm sure, well aware of the strict embargo and severe consequences of disobeying it. We'd be grateful if you would let us have any typographical or other minor corrections in writing that you attempt to agree an order, and to the extent that you can't, let us have any submissions in writing as to any disagreement, and we'll determine those in writing. And then the judgment will be handed down electronically in the usual way without attendance. And that concludes today's hearing. Thank you very much.